Welcome, everybody. I am the surprise moderator for the panel on Europe. And I'm Karin Karlaker. I'm the Director of Free Expression Programs at Pen America Center. And I'm going to be moderating this panel. We're starting a little bit late, and we have a great panel with a lot of speakers, but I am going to try to hold everybody to 10 minutes and be very strict with all the speakers. So you are going to get warned when you come near your allotted time. We'll hear from Frederic Gras about France.
Thank you.
Starting the timer.
Start quick. That's the way it was. So let's have a look to case law in France, and I will focus about apology and incitement to discrimination. And as you will notice, it's mainly textile repression. We can say that because of such a thing. You can see on this picture that it was about apology, and wearing a T-shirt could virtually bring your mum and uncle to prison. 2 months imprisonment, suspended, and a 4,000 fine. Why? Because of Article 24 of the Statute about freedom of the press. And it has been judged that this T-shirt was an apology of crime. And it was ruled by the court that such words on the T-shirt show in a favorable way the terrorist attack of September 11. Such a fact is beyond the limits ruled by Article 10, as Mr. Beggar used a young child to promote criminal acts, and which characterize the offense of apology of crime defined by Article 24. And as you can see on the T-shirt, you only have this inscription, I am a bomb. And on the other side of the T-shirt, you have the name of the child. The child is named Jihad. And it's written, born September 11. And it was ruled by the court that such a thing was an apology of crime. And you have also to know that this T-shirt was under a sweatshirt, so it was not possible to see it, and actually it was only seen by 2 people in the school, because the women brought the child to the toilets and they saw the T-shirt, and they told the prosecutor, well, there is a big problem with this T-shirt, and by this way we had such a rule. So what we can say now is that these provisions, which were in our law of the press, now they are in the criminal code, and the main difference between criminal code and the law of the press is that you have special proceedings in the law of the press, which protects press freedom. It's more difficult to sue. And when you put this provision in the criminal code, it's more easier to sue. And especially when you have such provision in the criminal code, you can have criminal expeditious procedures. And by this way, it's more difficult to have a good defense, because it's, you see, expeditious procedures are to justice what fast food is to gastronomy. And by this way, it's not natural to put such provisions in the criminal code. What do we have also about Dieudonné? You will see that we are talking a lot about Dieudonné. It's a good advertising for him to go to justice, even if it's more difficult for him to speak, because we had a judgment in March 2015 about Dieudonné, and after the terrorist attack, he told, instead of I am Charlie, he told, I feel like Charlie Koulibaly, and Koulibaly was the name of one of the terrorists. And it was considered by the prosecutors and by also a lot of Jewish associations that it was an apology of terrorism. And the prosecutor called for a fine of 30,000 euro and imprisonment if not paid. And you have to know that the maximum penalty is 7 years imprisonment and a fine of 100,000 euro. And the judgment was actually that he was guilty for terrorism, and he had 2 months imprisonment suspended, and that means prison if there is a new offense. And we can notice also proliferation of association as plaintiff, but only 2 were admissible, an Association of Victims of Terrorism and Association of Lawyers Without Borders. And you can notice that they had only €1 damages and 1,000 euro for legal costs. Another case in France is about BDS, demonstration for the boycott of Israeli products, brings fine and damages. Why? Because once again, because of Article 24, and the Court of Appeal of Colmar. Colmar is a former German city, and also the birthplace of Bartholdi. People from BDS were convicted to fines and to global damages for provocation to discrimination linked to origin and national membership. And why? Why such a rule? Because the Court of Appeal considered that provocation to discrimination is not covered by freedom of speech, as it constitutes positive act of rejection by incitement to discriminate between people, excluding one category because of its nationality. And this category is the producers of Israel. And the High Court, Cour de Cassation, ruled in October 2015 that people were inside the shop when the police came, and that they were distributing leaflets about Israel and naming the trademark linked to Israel. And the High Court solution was that the judgment had to be confirmed because of this. And you will notice that we have learned a lot about Mr. Erdogan and of Turkey, because it's the same motivation, you see. Freedom of speech guaranteed by Article 10 of the European Convention of Human Rights. We quote the European Convention, but after that, we say that it can be restricted by paragraph 2 of this article when those measures, as in the case, are necessary in a democratic society. But they do not have any motivation about why it is necessary in a democratic society. And this is the main point. We just quote the European Convention just to quote the paragraph 2 after that. Remarks. On one point, we can say that Article 24 is too wide for freedom of speech, and we should limit it to direct incitement to hatred and violence as in European case law. And perhaps also we can say that this Article 24 has to be abolished because it's really a great danger for freedom of speech. And we can also say that a criticism of a religion or a state should not be punished, as political offenses are forbidden in a democratic society for their chilling effects on freedom of expression. But on the other point, we can also notice that freedom of speech should respect freedom of the consumer and freedom of the shopkeeper. And as you can see on this image, how do we deal with intrusion inside the shop? And here we have a great issue. It's how do we balance between freedom of expression versus free trade and free consumer? How do we deal? We have a letter of the Minister of Justice from 2013, because BDS wrote to this Minister of Justice saying you have to abolish this kind of trials. And it was considered by the Minister of Justice that boycott is a violation of Article 24, which repress incitement to discrimination linked to national origin. And it was considered by the Minister of Justice that such an offense does not forbid the free criticism of the state or the public expression of a personal opinion. But how can you criticize the state if it's ruled that such a criticism is discrimination? So we do not have any solution in the letter of the minister. And it was also considered by the minister that this Article 24 is linked also to another provision of the criminal code, the Article 225(2), which forbids discrimination by hindering economic activity. And what we can say is that such a way of thinking is a strong political will from the government and from the past government, right-wing, and from the present government, normally left-wing, said, to prosecute discrimination and racist speech, also called, because is it racist to say that you have to boycott Israeli products? Yes. I think that, law is, facts make the law and history makes the law. I think that we just, the judges keep just in mind this boycott of Jewish shops during the 30s. And as you can see in this picture, it was a German stand-up, do not buy to Jews. Same pictures, but what we can notice is that in the case of boycott, they do not say do not buy to Jews. They just say do not buy Israeli products. It's a big difference. And also, they do not forbid to get into the shop. On this picture, you can see that you cannot get into the shop. In the previous picture, you can see they are around the consumers, but they do not forbid to buy those products. So I think that we have to be very careful about this Article 24, and a good thing would be to abolish this article, but I think I'm the only one lawyer to think this in France, actually, at the moment. And we are not really helped by the European Court of Human Rights because of this judgment of October 2015 against Dieudonné, really named Mbala Mbala, because they say you cannot ask for the protection of Article 10 when you infringe Article 17. But how can you say that the show of Dieudonné is an infringement of Article 17? I do not see any motivation and real motivation about this, but we will discuss this point later with the speech and the lecture of Aurelie about administrative law. Thank you for your attention.
Thank you very much, Frederic. And next we'll turn to Dirk Voorhoof for the European Court of Human Rights update.
I would have a preliminary question to the chairman to have a few minutes more. I'm reporting about the most productive regional court in the world, covering 47 member states. Discrimination is treatment, equal treatment of persons in a very different situation. So a little bit of clemency, but I do my best anyway. The right to freedom of expression 2015 case law by the European Court. Article 10 makes a difference in Europe. When we look at the case law over the years, we see that European Court in more than 600 cases overruled national findings and gave an added value, a higher layer of protection of freedom of speech. In 2015, there were 28 violations found, so that means still the court is on the track in highering the level of freedom of expression in relation to the situation in many of the member states. Which are the countries last year? Some countries once found in violation, other two. We just had France and Turkey here just in front of me. They are the best clients in Strasbourg. Turkey, 10 violations, mostly for the same reasons as in the past, incitement to the division of the population, terrorism, all overruled by the European Court. We should not look only at Article 10 cases. We should also look, for instance, at Article 6 cases. I think the case of Roman Zakharov clearly illustrates how mass surveillance can affect journalists and people working in NGOs and human rights activists. Or, for instance, cases where the European Court finds a non-violation of Article 8 by an applicant who felt that his right of reputation was not sufficiently protected in their own country, and the European Court gave priority to Article 10 in these cases, although they came in as an Article 8 case. We should also look at some Article 3 cases on inhuman treatment. The court has applied Article 3 in some cases of violence against journalists, specifically in 2 cases against Azerbaijan. And of course, there are also Article 11 cases, which is the collective right of freedom of expression that we should look at, but of course it's impossible in 10 or 12 minutes to go through all these cases. So many violations from very many different perspectives which create extra protection from the, by the European Court in Strasbourg. Is the whole overview of 2015 bright and positive? No. There are also some worrying judgments. I hope at the end I have time to come back on it. If not, you have a very biased view. If I don't succeed to give a little attention to these last 3 judgments in Pentikainen, Delphi, and Satakun and Satamedia. The issues of Article 10 are very much the issues we have been debating yesterday and in the other sessions today. And you can see them there. It's the hardcore of the discussions and problems regarding freedom of speech, media, and journalism. Maybe a horizontal aspect that comes back in many of these judgments by the European Court is the use of criminal prosecution and criminal sanctions in all these kind of cases, and the notion of chilling effect, which pops up also in the case law more and more by the European Court. Some positive cases, let's start with that. I think there are many examples in 2015 of judgments where the court again emphasized the need of robust speech in society, participating on matters of issues of public concern. Few examples: a case in Iceland, a case in Finland, a case in Romania, where the court clearly emphasized some aspects who create a broader breathing space for freedom of expression, and specifically also for journalists reporting on court cases, criticizing other journalists, and also other journalists need to accept that they are criticized by fellow journalists because of the content of a documentary. And the case of Morar was a political satire about the presidential candidate, satire that he would have been a spy of Securitate. Conviction for criminal defamation in Romania, found a violation by the court. A very important case, I think, is the case of Maurice versus France. It's a Grand Chamber judgment, which is really important for also the other 46 member states in Europe to give more possibilities to lawyers to participate in public debate. Here in this case, it was a lawyer who gave an interview about a case where he was involved in, and he saw clear indications of malpractice by the judiciary in that case. And the court, you see the quote there, gives the lawyer a right to participate in public debate and eventually to refer to the potential shortcomings within the administration of justice and to deliver constructive criticism. Also in the case of Bono versus France, we find a similar attitude. There are still some cases where lawyers transgress the limits, in the case of Fuchs and Peruzzi, but I think the new standard and the approach by Maurice versus France is a very important one also for lawyers working in sensitive areas to be in a possibility to bring some things under the public eye. The balancing test, Yaman referred to it, and we are familiar with it in Europe now after 3-4 years since the Axel Springer and Van Hannover 2 case. It gives some more guidance and the way the court is using these 6 criteria, and they have a good outcome. I give a few examples of cases where the court did find a violation of Article 10. Major cases, the Grand Chamber judgment in the case of Paris Match, in which the former mistress partner of the monarch of Monaco had an illegitimate child with, convicted in France, but European court found that also the woman and the child had their rights to expose their situation, and that the tradition in France that prime ministers and presidents have somewhere another relation should be kept secret, and that this is not a sufficient argument to keep the privacy of this monarchs, presidents and prime ministers. For another case, non-violation of Article 8, 2 public persons, a musician and the husband of the Princess of Monaco, were not amused with the commercial, which was humorous and who referred to their names, and they didn't succeed in their own country to have an award of damages for this humorous advertisements. They went to Strasbourg, but the court found that these humorous tobacco advertisements are protected under Article 10 and that there was not a sufficient Article 8 claim. Interesting also in the case of Karagia versus Romania, a journalist was acquitted for defamation of a CEO of an important commercial company. That CEO went to Strasbourg because he felt that the acquittal of the journalist in Romania was breaching his right of reputation. Again, a good outcome here by the European Court. There was a factual basis. This guy was involved allegedly in fraud. There was an investigation. And even if some statements in the article were potentially provocative, written in an inappropriate language, still there is the right of the journalist to exaggerate and provocate when reporting on issues of public issue. Maybe the most important Grand Chamber judgment to bring under your attention, very much debated, is the case of Perinček versus Switzerland, Grand Chamber judgment, in which the court found that the conviction of Perinček, a Turkish politician who gave a speech in Switzerland and denied or discussed the qualification of the genocide of the Armenian people between 1950 and 1920, that the conviction on the basis of the Swiss criminal law violated Article 10 of the Convention. Very interesting is also that the European Court emphasized that from now on Article 10 should be applied only in exceptional cases and in extreme cases, and the case of Dieudonné Mbala that our colleague just mentioned seems to be a bit in contrast with that principle. Maybe these judges were not well aware yet of the Grand Chamber judgment. Robust speech, no incitement to hatred, and interesting also in our global perspective here that the court explicitly referred to the General Command number 34, which contains a provision that memory laws can never be in accordance with Article 19 ICCPR if it's just denial of historical facts that cannot be criminalized. And there's a clear reference to that in the judgment. I don't need to come back on Cengiz. We had enough of that. They had an award, and we have also been informed that another guy was very happy with this award. Right of access to public documents, also an important development in the case law by the European Court. Journalists and NGOs can rely on Article 10 in requesting access to public documents, and this has been confirmed in a case against Bulgaria, not about human rights violations, but about animals' rights violations, because yesterday somebody made a reference that access when it concerns human rights violations should be broader, and that brings the question, what if it is about animals' rights? The court underlined the public watchdog role, stray dogs, public watchdog role, interesting. Using hidden cameras by journalists has been permitted by the European Court in the case of Haldeman versus Switzerland. I need to go fast. Whistleblowing has been protected in a few more cases. Reubens versus Latvia, with some very interesting considerations by the court, but also Kharlamov versus Russia, where a professor defamed his own university and he revealed some information, convicted in Russia, but found violation by the Russian authorities in this case. Very interesting also, Annan versus Germany, pro-life leaflets who are canvassing around the clinic where abortion is organized, let's say. Conviction in France because the doctors were compared with Holocaust doctors, Holocaust, baby coast. The European Court found that this interference could not stand the standards of Article 10 of the European Convention. I think a very interesting case. It seems to become a good news show from Strasbourg, and very positive as well the cases regarding Article 3 applications where the European Court requests member states to take action to investigate on attacks, violence that journalists are victims of in their country, both on the procedural and in one case also on the substantive element. The negative cases, no time anymore to elaborate on them, but I just need to mention them. Delphi, very well aware amongst this population and audience, very worrying trend, reducing the safe harbor principles and putting liability on the internet news platforms. There's a recent case of February and a case of Hungary, which more or less confirms Delphi. Case of Pentikainen, very worrying judgment, the conviction, arrest conviction of a journalist because he disobeyed a police order while he was covering a demonstration. So that's a very worrying trend, and you can see some of the considerations of the European Court are difficult to understand. A journalist has to be aware that he assumes a risk. He's not entitled to have a preferred treatment, and the court says that we need to avoid any impairment of the media's watchdog role, but still it didn't find a violation of Article 10. Hard to understand. Satakunen on the notion of journalistic activity as a derogation on the processing of data. 2016, many cases are to come. I think Baka is very interesting, the right of freedom of expression of a judge criticizing the government, a former judge of the European Court of Human Rights, by the way, that comes to the Grand Chamber. An interesting case on access to public documents, Grand Chamber judgment. It will be very important because in some countries they do not accept yet the application of Article 10 because they say there's no Grand Chamber judgment yet. It's only some chamber judgments who have applied Article 10 in access to information cases. That will be an important one. And I thought this one would still need to come, but it has been delivered last week. Another worrying judgment, Vidar versus Switzerland on court reporting. No time to get over it. 7 important issues for 2017. You can see them there. Protection of journalists against violence, news gathering, defamation, whistleblowing, protection of sources, access to documents, transparency of intelligence services, and the strict scrutiny test by the European Convention, and the chilling effect, which is a real VUCA environment. It's very volatile, uncertain, complex and ambiguous, the way how the European Court uses chilling effect. There's a case, one of the European Court of Justice, but it would take me 10 minutes to explain, so I skip that and I end this overview. Thank you. Thank you for
Very nicely done, very efficient. Unfortunately, we do not have Olga with us today because she is sick to talk about Russia. Next, we'll be jumping to Vidar Stromme from Norway.
Thank you. The thing that moves. Thank you. And thank you for the invitation. Thank you, Dirk, for going through the European cases, which is very important for us. And your speech reminded me of the play, The Complete Shakespeare, in 90 minutes. I don't have so many cases to talk about. Really, 2. One of them has already been mentioned quite a lot, so Boltzmann case. But I'll So I feel it's a little bit unfair that I also have 10 minutes. But,
That's okay.
Yes, absolutely. And the point is really to get an overview, and then we can work afterwards, all of us, when we need to. So before coming to these two cases, I thought I would mention just two background issues here, which is the main reason for the PowerPoint, really, because we talked yesterday about the non-legal norms, the development of non-legal norms, and dialogue between the courts. And I thought that Norway might actually be quite a good illustration of the impact of other factors than the content of legal norms. Because here you see the history of defamation cases in Norway towards the press. It's blocks of 10 years. It's the 70s, the 80s, the 90s. And you see the number of cases increasing, and you see that the media loses most of the cases. And then something suddenly happens in 1999, because suddenly the media wins most of the cases, and afterwards the cases disappear. So what actually happened? Well, the content of the norms, the legal norms, did actually not change, because Norway has a dualistic system, and we had ratified the European Convention on Human Rights, but we didn't see any conflict, so we just applied the European Convention, and everybody thought we followed it in detail, and that everything was okay. Then three or four things happened between May 1999 and May 2000. The first three things was that Norway lost 3 cases in Strasbourg, where the Norwegian courts had sentenced media's newspapers in defamation cases, and the media took the cases to Strasbourg, pretty old cases, but in 1999 and one in 2000, the Norwegian media lost those cases. It was the Tromsø and Nilsen and Johnson and Bergens Tidende cases. Nobody pointed to any conflict between the legal norms, but Strasbourg came to other conclusions. And in addition, in 2000, Norway also incorporated the convention directly into national law. So, but that did not imply any change of the real content of the legal norms. But even though nothing happened, this changed dramatically. So what happened? Well, you might say that judges started to have a greater fear of being overturned. So we got the fear as a source of law, possibly the fear as a source of law. So what legal norms did judges internalize in this period? Difficult to say, it's been discussed, but I think a good guess could be, let's take freedom of expression seriously. Really. So that explains why the media started to win the cases. And then the number of cases also decreased dramatically. And since we yesterday discussed norms and used terms from sociology, I think we might also have a look at expectations, because defamation cases are often driven by a kind of revenge, and revenge is based on expectations, not least in my experience from the environment of the persons considering going to court. Wives, husbands, business partners will say, look, you're on the front page of the newspaper. If you don't want to look like an idiot and have everybody believe it's true, you have to sue somebody. And then, okay, they go to court, even if they really don't want to. But when we then take this tool away, they don't have to go to court anymore. This expectation is gone. It's like the other side of this dog poo example we just discussed yesterday, where we created a norm, an expectation to remove this from the street. Removing defamation cases as a practical tool also removes expectations, and I think expectations might be a little bit more solid than norms. So that was a little little argument in the sociology of international norm building. Okay, use several minutes for that. Let me also mention as a background that the law legislation in Norway changed in 2015. We followed good advice from experts and decriminalized defamation, which is now only subject to torts in civil cases, and the rule itself is more or less a reference to Article 10 of the Convention, so that it can be flexible and keep up with the European Court's dynamic interpretation. On the other hand, violation of privacy, which is a strong rule in Norway, is still criminalized. And at the same moment as defamation was decriminalized, the punishment, the possible punishment for violation of privacy was quadrupled, actually. So the thinking is that because you can be hunted in the media, you need to have a safe haven. It's two sides of the same coin, which is not quite so in harmony with Strasbourg reasoning now, where privacy and defamation is seen as the same. Well, the minutes are running. We have the Boltzmann case. I think that I will not go through that at the surface, but let me hammer in the bullet points so that you might have questions afterwards. So you learn the case. Well, it's about seizure of the Norwegian Police Security Service documentary footage from the filmmaker. And the point of making this documentary was to identify the motives of Norwegian citizens becoming foreign fighters. So the police and this filmmaker was hunting for the same, what is actually going on, but from different angles. And what the Supreme Court said was that this seizure was invalidated as, quote, based on the protection of unpublished material which may expose unidentified journalistic sources as established by Article 10. So you might note the word may expose unidentified journalistic sources. Wide source concept, accepting the value of this work of the filmmaker, and as I mentioned yesterday as well, chilling effect, a good and thorough understanding of what is really chilling effect. As a lawyer, I've often found it difficult to explain what is this chilling effect, and always impossible to explain in the lower courts, but sometimes possible in the Supreme Court. And now they really understand it. So the second case is the other way around. The Rolfsen case was about the police wanting to have film from the media. The next case is about the media wanting to have film from the police. In other words, the right of access to information, where we were up to these arguments that Dirk mentioned. There is no real clear case from Strasbourg, so how should we deal with this back home? But the Norwegian Supreme Court came to the conclusion that the Norwegian Broadcasting Corporation actually could get access to this film that was taken at the hospital where an ambulance driver had killed a person. So because there would be no court trial, there was sufficient legitimate right of information. So the point is really here, more or less, that the Supreme Court found that there was such a rule, even if it had not yet been clearly said from Strasbourg. Last point is just to point at thing that is a nice thing to do is to check whether the actual freedom of speech in a country is as the same as we lawyers think it is. I will not go into it, but it's a broad project that tries to analyze various kinds of actual freedom of speech. Thank you.
Thank you very much, Vidar. And now we will turn to our last speaker, Aurelie Bretonneau of France Conseil d'État.
I don't have a PowerPoint. Do I stay here? Or?
Either, whichever you want.
Okay, so
It's your choice.
is it okay?
Yeah, yeah.
Just give
All
me
right.
the thing.
Hello.
Very
So, as it was said, thank you. I'm a member of the French Conseil d'État, which is a French administrative Supreme Court, distinct from the Cour de Cassation. I think it's the first time the Conseil d'État is represented here, so thank you for inviting us. It's quite understandable because we are less exposed than the Cour de Cassation to the question of freedom of speech. We don't have the power to send people to jail, so what we do is less important than the Cour de Cassation, but we are occasionally facing questions about freedom of speech, especially when we review the decisions taken by the administration in the framework of its administrative police powers, which include the possibility sometimes to prevent some events, for example, shows or meetings, to take place in the name of public order. So having said that, it's quite challenging to expose you the somewhat original vision of free speech from an administrative police point of view in France, especially as regards 2015 case law. 2015 has been a strange year in France for free speech. It has opened with the January attacks against Charlie Hebdo, leading millions of people to take to the street in support of free speech. And it has ended with the proclamation of the state of emergency in the wake of the November attacks. State of emergency which potentially can lead to restrictions of liberties in general and freedom of speech among them, even though the renewed state of emergency legal framework now excludes the possibilities of restricting publications in the name of a state of emergency that used to exist before. So this is a restriction, but still you can attack liberties in this legal framework. In the meantime, 2015 has also been marked by vivid debates about hate speech, especially through the judicial saga of Dieudonné, Frederic has mentioned, because apart from his condemnation for supporting Charlie Koulibaly, the Conseil d'État has also be referred to of a series of decisions banning the show, one of his shows, in several French towns because the show was insulting to people from Jewish origin. And the Conseil d'État has stated that the banning was legal in a series of cases. Finally, on a much lighter topic, the French administrative jurisdiction has been literally assaulted by applications from a conservative association, which is called Association Promouvoir, which goal is to make sure the regulation about movie classification, which goal is to make sure which goal is to prevent the broadcasting of movies, the diffusion of movies to the young public, is correctly enforced, and its crusade has resulted in a series of also controversial decisions quashing the authorizations the movies had been granted with. So I will expand on that. First, maybe some elements of backgrounds for those of you who are not very familiar with the French administrative system. Of course, French protects freedom of speech at the highest level. Through the Declaration of Rights of Men and Citizens, which states that the free communication of thought and opinion is one of the most precious rights of man. and through the Article 10 of European Convention that we fully implement in France. But both texts allow for certain restrictions to free speech, most of which consist in penal incrimination, exposing transgressors to be sentenced by the judge. But French administration is also granted with administrative police powers that allow local state authorities to prevent certain forms of expression before they even occur. So as a general rule, local authorities, either the mayor or the prefect, have a responsibility to ban public events that might cause public disturbances or harm, possibly in the name of free speech, certain values, especially the dignity of the individual. And in some very specific area, the government also has a word on the issuing of certain works. For example, it provides for movie classification in order to ensure young spectators are not exposed to a great deal of violence or pornographic scenes. And it also supervises publication for the youth, mostly also in order to prohibit the sale of pornographic books to children. All these administrative decisions can be appealed before an administrative court, and the administrative judge fully controls the adequacy and proportionality of the resulting restriction to free speech as regards the pursued objective of protection of the public order. So about hate speech first, and the banning of shows in the name of public order. As I said, 2015 has seen the outcome as far as the Conseil d'État is concerned of the Dieudonné saga. In fact, the year before, in 2014, as Dieudonné has announced a great tour all around the country during which he would present a show containing anti-Semitic tirades and gesture, the Ministry of Interior issued guidelines explaining to the local authorities in which case and under which provision they could or could not ban the show in their town. On this basis, several shows were banned, and the Conseil d'État, stating through an accelerated procedure, confirmed the banning, justified by both the risk of public disturbances and the risk of serious harm to the values and principles, particularly the dignity of the individual. In 2015, the Conseil d'État more generally stated on the legality of the guidelines provided by the Ministry of Interior. Whereas the impact of the 2014 decisions was confined to the specific local cases referred to the court, the 2015 decision has a wider range, as it draws the general framework of what kind of speeches can or cannot be preventively forbidden in the name of dignity. So according to this decision, the criteria are the following. Firstly, the show can be forbidden only if it carries a risk of public disorder, which can be material, for example, in the case of riots that are suspected to occur in the wake of the show, or immaterial in the case of infringements to dignity. In this respect, the circumstance that such a public disorder could, if not prevented, result in a penal sanction is not an obstacle to preventive banning. This specific point, which had been so thoroughly debated, lots of people being shocked at the idea that words could be banned before being pronounced, actually fits with a long French judicial tradition, so it's not a novelty in the 2015 decision. But secondly, the banning must be adequate, necessary and proportionate to the preventive objective pursued. So this is very important because it means that whether all penal infringements are worth punishing, not all of them are worth preventing. So this is very important, particularly in the case of immaterial offenses. Actually, preventive banning in the name of dignity requires a very rare cocktail of circumstances to be stated legal. The immaterial offense must be of particular seriousness. This is the case, of course, of anti-Semitic insults inciting to racial hatred and praising Holocaust and crimes perpetrated during World War II, which was the case in the show, the very particular show that was banned in the Dieudonné story. Then the realization of the offense, if not prevented, must be almost certain. This was the case also with this particular show, as the text of the show was which was previously performed, was known in advance. So we knew exactly what Dieudonné was going to say. And then there must be no other mean, less aggressive for free speech than the banning, liable to prevent the offense from occurring again. And again, this was the case with Dieudonné, who had already been condemned 7 times from anti-Semitic insults and had publicly declared his wish to do better in that matter. So he wanted to do more, be more anti-Semitic, which made completely illusory the idea of him complying, for example, to an injunction of suppressing some parts of his show. We knew that he wouldn't comply with that. So that was a very, very specific context. So this decision certainly confirmed the trend of banning that have caused Dieudonné to describe himself as a martyr of free speech. But it also makes the Dieudonné case already very difficult to be reproduced again, because it's a very strict cocktail of circumstances. So I will only say a few words of the trends and expectations for 2016. As I said first, I don't think we will have more Dieudonné cases, and it's important to note that by the end of 2015, a new decision of the Conseil d'État quashed the banning of another show of Dieudonné, because it stated that in this very particular case, we had no certainty that it would be tremendously horrific. And so this is not systematic at all. It was a very peculiar case. About movies, we had a series of decisions in which the Conseil d'État was led to quash authorization that have been granted to show movies to people over 16, and we were led to say that no, it was over 18. So the film producers were furious. But compared to the Dieudonné case, the Conseil d'État had no margin of maneuver, because the law is very strict, and we have terms of law that impose to forbid those violent movies or sexual movies to people under 18. So the Ministry of Culture has announced a reform of the law that might be changed in order for the judge to have more latitude in order to take into account the intention of the filmmaker and the artistic way the scenes are filmed. Last thing, 2000 will be the first year when the Conseil d'État pronounced itself on the right to be forgotten, because in the wake of the Google Spain decision of European Court of Justice, the French regulator of the Internet has been seized of a series of complaints of people wishing some links to be removed from the search engine of Google. And the Conseil d'État will, in a few months, state whether it was legal or not. About the first case will be about a local politician of not much importance that asked a caricature of her to be removed because it presented her as having had sexual relations with another local politician, and stating that it has led her to obtain certain advantages. So it is to be monitored.
Great. Thank you so much, everybody. And thanks to my excellent timekeeping, we now have almost 15 minutes for a Q&A session. So I'm sure there will be a lot of good questions for all the presenters. So with a question.
It's just a question to Yaman. What happens if the media means don't obey the orders to ban links or materials? What happens?
They could be fined. They could be fined and they could be prosecuted as well. So both civil claims and administrative fines, sorry, and also potential prosecution. I mean, these orders, the banning orders on media are so vague. It involves also not just the media, but social media criticism, they say, or sharing photographs, for example, from the scene of the bombings, and so covers everyone. I mean, it has a chilling effect on media, and because the fines, administrative fines, are so high that when media companies just stop reporting, basically, and they don't know what to do because it's so vague. But it has an effect, unfortunately, on the government-related or those who are on the side of the government news agencies. They continue reporting and nothing happens to them. So it's a selective application as well.
And yes?
Thank you. I have three questions. The first is to Dirk. You highlighted a lot of very interesting positive cases, and then 2 or 3 that were not so good. So why is it that usually in your overall analysis of the European Court, you tend to focus so much on the negative cases? Do you think that they are, at a trend level, do you objectively think that those 3 cases are demonstrating a worrying, a real concern regarding where the European Court is going? I'm trying to understand the thinking process and the methodology. My second question to Vidar is how, I don't know if you can answer it, but how do you compare to the rest of Scandinavia in terms of your very interesting, progressive ruling and legal culture around freedom of expression? And then France, I mean, there are so many issues that those 2 presentations raise. I don't even know where to begin. It's clearly, so I have 2 questions. One is to both of you. Have you seen a marked impact in the court of the state of emergency? Of course, theoretically, yes, but has there been a marked impact? And then, of course, around the BDS, the boycott movement, which I don't know of any cases outside France, but I know there have been legal issues, laws. But maybe Charles can tell us more if there have been if there have been cases around sanctioning legally sanctioning the call for sanctions in a court, beside trying to pass laws. How do you see the next step there? What's going to happen in the coming year over these questions in France, at least?
Okay, great. Why don't we take a few more questions, and then we can let the presenters jump in. So.
Yeah, good morning. Two questions for the Conseil d'État regarding the right to be de-indexed. The first one is, when the Conseil d'État will examine those cases next year, it will be as an appeal to the decisions by the CNIL, right?
Yes, exactly.
Okay. And the second question is, one of the tensions at the moment is the fine that the CNIL has put on Google for not extending this internationally. The Conseil d'État would be the right venue for any appeal that Google might make against this decision, right?
Yes.
Directly to the Conseil d'État.
Yes, we are competent for all the decision related to the CNIL in the...
That's what I thought. Just because it was an answer to a question that was raised yesterday.
Okay.
Okay.
Great. Further questions, Karina?
Vidar, I had a question for you. You said something interesting, and I'm not sure I quite got it. But you said something interesting about, was it that there's no longer an obligation to clear your reputation by suing for defamation, and that's norm creation because Norway's lost at the European Court of Human Rights level? Is it because people then realize that there's stuff that's said in the paper that isn't necessarily accurate? I didn't quite get that.
Okay, I'll let him think about it. Further back in the room. It's like, we'll do a round.
This on? Do you hear me? Yes, now. I wondered for anyone on the panel if you possibly would have any reflections on the new tendency of hybrid warfare and freedom of expression, in particular, of course, propaganda of war aspects of it and disinformation. Now, I realize that this is perhaps more of a East European concern, and you have dealt with other countries, and maybe one that is more upcoming in 2016. Nevertheless, I think that yesterday we had Dunja Mijatovic, and I know she has expressed concern, for instance, in practice of already cases happening, like in Latvia. There was a takedown of an internet information site on the basis of national security, of course, and also the development of legislation when it concerns this, and arguably the even broader concept of national security than concerning the terrorism legislation. Please.
Okay, great, thank you. Any further questions? Further? Nope. Okay, we'll do a round. Let's see. Do you have any?
Do you have questions on that?
No.
All right.
Do you have answers for anyone? You can go first.
Me?
Yeah, you do anything.
About BDS and what will be the next step, I think if we do not change the law, the Cour de Cassation will keep the same way of thinking, and but I think that they will have to explain and to go further, because I've seen that in the newspaper, the French newspaper in the plane, that no, we will have another boycott. It's about Islamic fashion. And Elisabeth Badinter, who is a philosopher, saying that women have to boycott some trademarks named H&M and Dolce & Gabbana because they are producing this kind of thing, and so it's Islamic wear, and they say this philosopher say you have to boycott this trademark because they are producing Islamic wear, and by this way it's not a good thing for women and for feminists, and in this case, it will be quite interesting because it's about Islamic, and in the Article 24, it's forbidden to provoke to discrimination, especially when it's around religion. And by this way, it will be very difficult to explain that it's possible to be convicted because you are provoking to boycott Israeli products, but that you do not have to be convicted when you saying that you have to boycott Dolce & Gabbana because it's producing Islamic wear. So we will have perhaps a good deal of Cour de Cassation on this. But what we have to say is that we have this judgment of the Cour de Cassation, but you have also a judgment from lesser high degree, first degree, and Court of Appeal. For example, the Court of Appeal of Paris has a completely different way of thinking this provision of Article 24, and we had different judgment saying that it was not an offense to have a provocation to boycott of Israeli product because it was a criticism of a state and not a provocation to discrimination about Jews. And that's why it was ruled by the lawyers in front of the Cour de Cassation that the French law was not was not precise and was did not have the quality of law as in European standards, because you had different rulings from the Court of Appeal, but the Cour de Cassation didn't go on this point, saying just that it's okay with Article 10. You can forbid such a boycott because there is paragraph 2, without any motivation about this paragraph 2 and the way of implementing this paragraph 2, that is to be necessary in a democratic society. And I think the main remark and the main criticism that we can have about this judgment is that there is no real motivation upon this subject. About urgency, I think the main problem we had is about apology of terrorism, because they have put the provision of the law of the press in the criminal code, and by this way now you can have, as I've told, you can have expeditious proceedings in criminal court, and we had a lot of decision against people just saying that well, if I was like the terrorist, I would have done the same. But there are mainly crazy people. They are not really activists and Islamic activists, and we had a lot of repression, a lot of prosecution, but without real way of thinking this repression. And I think the main impact of urgency is that the government and the prosecutor want to show that they are doing something, but what they are doing is not good, actually, especially for freedom of speech, because we had an attempt against Charlie Hebdo, and the result is that now we have more provisions against free speech. We have more prosecution about free speech, and also we, as we have seen, we had a lot of mayors who forbid the show of the données. But you have also another point, is that you have an Islamic philosopher from Switzerland, Tariq Ramadan, and Tariq Ramadan is forbidden to give speech in towns, in French town, because people think that is Wahhabite, and by this way you cannot tolerate such conferences. And I think it's very dangerous, because you cannot forbid you cannot forbid speeches, and you cannot forbid Islamic speeches just because they are Islamic. I think it's not a good way of thinking tolerance. And we have the same problem actually in France, because in France we are thinking to forbid the new publication of Mein Kampf, saying that you cannot publish Mein Kampf because it's a Nazi doctrine. But it's also very interesting from an historical point of view. And it's possible also to find those old books. So why could it be forbidden to publish a new book upon Mein Kampf? If you want to struggle against Nazism, against Islamic, you have to know the doctrine. If you do not know the doctrine, how can you find it? So I think we have to fight for free speech.
Thank you, Frederic. Yaman, any
Just one thing. When Dirk, you mentioned the Perinček Switzerland case, of course that's an important decision, and he has a different angle, because though Perinček is a Turkish politician, and so to his defense, Turkish government came and they had a huge influence on the case. They made a 70-page submission that I've seen, and interestingly, they're very well aware of the Article 10 criteria, and they argued in this case that there was no pressing social need for Doğu Perinçek's prosecution in Switzerland, and that it was not necessary in a democratic society. All the case law and everything they mentioned, you know, I wouldn't object to, but the contrast is that when it comes to cases in Turkey, they do completely the opposite. So I just wanted to briefly mention that. Thank you.
Great, thank you, Yaman. Dirk, you're next to respond.
Yeah, the question on the trend. Already in 2008, together with a colleague of Strasbourg, we have organized a conference because we thought there were some clouds in the blue sky popping up in 2006, 2007. I think these dark clouds keep on popping up, but the sky is still blue. And I think also in my introduction, I gave that as long as European Court is keeping to find violations, it creates an added value. But this might not be good enough because we feel indeed that the last few years the pressure is increasing. And I think that has to do with the fact that in many member states, and there are just good examples here, France and Turkey, but also other states where nationalist parties get more and more on themselves. They don't like to be overruled by an international court, by the Strasbourg Court of Human Rights, whether it is about prisoners' rights or where you can put crucifixes in schools, or what rights do you give to minorities or asylum seekers. They want to proceed with their own nationalistic policy. So there is a pressure to reduce the active role of the European Court, and we can see that in some of the documents regarding the future of the European Court of Human Rights, in which member states request for a more broad margin of appreciation, recognition of the subsidiarity principle. So we'll need to see if the court will be strong enough to keep the track, to keep its line, but there are some indications that here and there it's weaker. And I see it specifically, and that's maybe the most worrying, at the level of the Grand Chamber. It's not by coincidence that Pentikainen and Delphi were two Grand Chamber judgments. There were very good reasons to expect that the Grand Chamber would find a violation. These cases were supported by massive support by stakeholders of media, human rights organizations, etc. And still, it seems the Grand Chamber, or they didn't understand where these cases were about, but I'm afraid that there at that level, the political influence is a little bit bigger than at the section level. This is off the record, I think, what I'm saying now. But this is a worrying element, so we need to follow that from very close. And the last judgment of last week in Vidar versus Switzerland, a new Grand Chamber judgment, confirms this reason to be worried about what comes from the Grand Chamber. And that's with regard to the trend. And so I hope in 2016 to be able to give maybe a more positive overview, but I will claim in advance to get a few more minutes to that overview. Scandinavia, it depends, because also in Scandinavia they discuss how big Scandinavia is. Is it only Denmark, Norway and Sweden, or does it only include, or does it also include Finland and Iceland? I think the big Scandinavia, also there are quite some differences. For instance, we can see quite some cases coming from Iceland and Finland the last few years regarding freedom of expression. So it means that also in these Scandinavian countries there are quite some issues. But let's say in general, Norway, Denmark and Sweden, yes, I think there, if you compare with the other countries here, France and Turkey, that there is a much higher level of freedom of speech. Let's make it clear, we heard a critical analysis yesterday, but the cartoons in Jyllands-Posten have not been convicted in Denmark. There has been a private prosecution public prosecutor didn't want to prosecute. There was a private prosecution, but the court, finally, also the Court of Appeal, found that there was no reason to convict the publication of the cartoons in Denmark. And so don't have a misinterpretation, but there are some issues maybe which deserve our attention. I think overall, Maurice Perinček, the cases on access to information, on protection of journalistic sources, on whistleblowing, no imprisonment of journalists, this all comes from Strasbourg. So let's hope that the European Court never takes one step back of what is acquired at this level. We need to follow what in new domains like Delphi, like in Pentikainen, can be done. I think also this community can play an important role. We can sit and complain about Pentikainen, but there is one organization, MLDI, who is supporting now a Russian journalist who was prosecuted in St. Petersburg for covering a demonstration that got into a riot, and this case is now in Strasbourg. So let's hope that with good material, the next time European Court can come back on its failure, because Pentikainen was a mistake, and work on good cases, strong cases, who can help to European Court to improve its approach again. And the last thing on propaganda, it's a hot issue in Europe. For instance, there is a review procedure on the Directive on audiovisual media services, and this is one of the main points of discussion, whether the member states will be in the position to have an extended competence to restrict the incoming of broadcasting programs coming from other countries, and this is precisely on demand of some of the Baltic countries being exposed to some very aggressive broadcasting networks from Russia, established in Russia or established in some other European member states, and profiting from the free flow of audiovisual media services, but not being sufficiently controlled in the countries where they are established. So it is a very hot issue, but my personal opinion is be careful to open too much possibilities, to give member states, receiving states, the possibility for a protectionistic policy.
Great, thank you very much, Dirk. Vidar, next?
Yes, let me first of all say that I agree on your analysis of Scandinavia. I too think that there are some variations, but it's more or less the same status on the various questions on freedom of speech. An example of a variation is that in Sweden it follows from the legislation that it is prohibited to investigate who is the source of the media. So that's a very strong protection, but on the other hand, the concept of a source is somewhat more narrow. So there's variations, and for the time being, we have the newest Supreme Court cases, which are clear, so we're leading for the time being, but the Supreme Courts in Scandinavia look closely at each other, so I would say that it's more or less the same, and I think it's overall positive. And then again, what is threatening is what comes from behind, as I usually say. It's secret police and so on with their actual doings and investigations. And there was also a question about the lack of necessity to sue for defamation, which was an attempt from my side to say something about psychology and sociology and not the law. My point was that as people tend to lose defamation cases, the defamed persons will feel less pressure to go to court simply, and as when that has been going on for a time, it will be more or less okay. And if somebody wants to call me an idiot in the newspaper, well, let them. I don't need to ruin my own life in the next 10 years by being in the courts. So it's like in Italy, where people used to kill each other for generations. Once such a habit is stopped, it's possible to live without it.
Here. Finally, Aurelie, any final
Thank
comments?
you. Yes, just one word about the state of emergency. In the Conseil d'État, we were very directly confronted to the state of emergency because we are the jurisdiction in charge of reviewing the individual decision taken by the government against people suspected from terrorism in the framework of the state of emergency. And in particular, we have had to review the decision assigning some persons to their residence, so they're not allowed to move, and because they're suspected of terrorist activity. So it's not directly linked to freedom of speech, but it has obviously connections. And the good news is, and it's something that is also relevant for the banning of shows, for example. The good news is that the accelerated procedure before the administrative judge has proven very efficient, I think. It's a special procedure that makes people able to seize the judge when a fundamental right is at stake, and the judge can state within 24 hours or 48 hours, so it's really quick. And for example, in the case of the show, it allowed the Conseil d'État to pronounce itself before the date of the show. So it's also very important in the balance of our weird preventive system. We have to keep in mind that yes, the administration can prevent some events to occur, but the people concerned are also able to seize a judge before it's effective. And so you have a judicial decision which changes a little bit the balance. And about the state of emergency, one of the good news was, so we had lots of application from the people assigned to residents. Most of them did seize the Conseil d'État. And the good news is that we observed, if you look at the stats, we will see that the Conseil d'État cancelled some of the measures, but not that much. But in fact, what we saw is that in very, very numerous cases, almost 40% of the cases, when the government saw that the judge was referred to, and that the file was serious, because the real bad guys, they don't go to the court because they know that they have no chance of winning. So most of them seize the Conseil d'État because they know that the file is not so good for the administration, and that the administration has been a little bold and has not many elements against them. And in almost 40% of the cases, once the judge was seized, the government cancelled the measure assigning the person to residence. So they say, okay, maybe we went too far on that one. You cite the judge. We are almost certain that our case is not good at all, and so they cancel the measure. So this is good news because it means that the judicial review is efficient, and that the perspective of having a fully proportionate control by a judge at least prevents the administration of going too far. Obviously, a better news would be that they don't take the measures in the first place. I agree, but at least we're not totally useless.
Great, and on that note, let's thank everybody on the panel.